In the judgment of the Presidential Election Tribunal, we have the views of two senior advocates of Nigeria. Also showing on the program, more from the recently concluded Annual General Conference of the Nigerian Bar Association, plus a recap of the top trending stories from the news. Hello and welcome to the program. I'm Shola Shieli. On Wednesday, September 6, the Presidential Election Tribunal finally delivered the long-anticipated judgment in 3 petitions filed before it to challenge the return of President Bola Tinubu. Let's bring you some of the excerpts from that judgment before we take some of the reactions trailing it.
Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than 2 candidates, as in the instant case. Not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the result declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, the 4 issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the 3 petitions, number CA/PEPC 03/2023, CA/PEPC 04/2023, and CA/PEPC 05/2023 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected President of the Federal Republic of Nigeria. The parties in the 3 petitions are to bear their respective costs.
Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or that it is difficult to prove the state petition. In the instant case, the petitioners' pleadings were deficient, while they complained of non-compliance with the Electoral Act against first respondent. Their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment.
Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW12, the petitioners exercise that right and add 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence.
And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European election observer missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough.
It is clearly evident that the decisions in Exhibits X1 and X2 tendered in the two petitions, respectively, as well as the decisions of this court in appeal number CA-LAG-CV 332-2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioners' contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the RF. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number PAPC 03-2023 and CAPEPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit.
Now, there's been so much reactions that has greeted that judgment. Two of the three political parties, talking about the PDP and the Labour Party, have indicated their resolve to challenge the judgment on appeal. Lawyers have also been commenting on the judgment. We have the reactions of two senior advocates up next.
I think the judgment reflected what was put before the Presidential Election Petitions Tribunal. Their lordships were very calm in analyzing the case that were brought by the different sets of petitioners. So you have a clear picture that they took their time in identifying the issues raised by the petitioners for determination and the objections that were raised by the respondents to the issues raised by the petitioners. At the end of the day, you have a sense that their lordship did justice according to law in respect of the issues submitted for determination by the parties. So I do not think there will be controversies. People may accept the decisions, and people may say, no, let's test the decision at the appellate court, this time the Supreme Court of Nigeria. It is within their rights. But the most important thing is that their lordships accredited themselves nobly, took time in identifying the issues, discussed them, and came to their conclusions. It is important that a judgment is meant to address issues that are raised, not outside the court or the tribunal, but within the precincts of the court or tribunal. So unless there is contrary view that the issues that were determined by the tribunal were not those raised by the petitioners and the respondents in answer to the petition by way of objections, and you could see that there were several rulings in respect of the various objections and issues that were raised. But because the electoral law has made it such that all interlocutory rulings should be taken together with the final ruling so as to save time and so as not to unnecessarily delay the trials. So you can see that all those rulings were taken before the final judgment in each of the three petitions, 3, 4, and 5, in respect of the 2023 presidential election. So to me, the judgment reflects, from what I listened to, the issues that were brought before the tribunal for determination. I don't think the judiciary was under pressure. This is not the first proceedings that the judgment has been streamed live, but I think because they knew that a lot of hullabaloo has been put in the public space to try to paint the judiciary as being under the authorship of certain particular sets of people. And if you look at the pedigree of their lordships, impeccable. If you listen to the diction, the language, the erudition, the sense that the judgment made, you know that they were not playing anybody's game. They were writing their names in the sands of time and history in this country. And when you look at the precedents that the judges referred to, you cannot fault them. You cannot. The Supreme Court may hold a different view, and the Supreme Court may agree with them, either in totality or by division.